to be a geographical limitation that was reasonable and a period of time that was reasonable. You can't do it for 100 years, but you can do it for a reasonable period of time in a reasonable geographic situation in order to protect yourself, and that's exactly what we have here. That's what the hospital's doing.
Great, thank you. It's like going to school.
Thank you.
Thank you.
Oh, I'm sorry. I did have something on my list and thought I crossed everything off. I raised this question several meetings ago, and Mr. Donovan was not prepared at that time to give an answer, but promised that he would be prepared.
This is like my night. Every third meeting.
That retainer's got to be for something. Could we have a list of the litigations against or by the village, and a brief description of what they are and where they stand?
Briefly, my recollection, my best recollection is there are 5. One involves the village, to the extent that we had one of our officers is assigned to the Orange County Child Abuse Task Force. There was a complaint made by an individual, an allegation of child abuse. That complaint was followed through by the school. This officer was called in as a result of his employment by the Orange County Sex Abuse, Child Abuse Task Force, though he is an employee of the Village PD. His salary is paid by Orange County, but he is an employee of the Village PD. It was ultimately that case was found to be unfounded, so the parents commenced a lawsuit against the school district and the village, the school district and the village is named as a party defendant as a result of that officer being an employee of the PD. As being handled by our insurance company attorney, there's presently a motion for summary judgment that's been made on behalf of the village and the school district. That's in front of the federal court, and they're waiting for a decision on that as we speak. Secondly, there is the Rexburg lawsuit that involves a former employee of Joint Rec. That's also being handled by our insurance company. There have been various conversations and discussions about settlement. I'm not privy to exactly where that is now. Parties defendant are Joint Rec, the town of Goshen, and the village of Goshen. There is also the lawsuit against the town of Goshen, where we're seeking recompense for our sewer fees that we allege are owed. The town is seeking arbitration, and that matter will be ultimately determined by the court as to whether or not we arbitrate or not arbitrate, and then we'll go forward. There is also the Carlin lawsuit that they commenced against us, Carlin being the general contractor at the wastewater treatment plant. That matter is being handled by Norton Christensen on behalf of the village. There's been extensive discovery. I anticipate my last conversation with Norton Christensen is that they were going to make a motion for summary judgment on behalf of the village seeking to dismiss Carlin's complaint. Last is Edgepath was over.
That's over.
We prevailed on that to the extent that the law allows us to prevail. The last one is the Epsilon lawsuit, where they don't want to pay their sewer bill. I spoke to their attorney as recently as last week. He wants to settle. He's got to make a settlement offer to the village board. The village board will decide whether to accept it or not. He claims the meter is not properly working. I can tell you, not telling any tales because it's all public record. We've had the meter calibrated on a regular basis, and it's shown to be working properly.
Was there a suit against Cloud Harbor?
By the village?
Or against the village by Cloud Harbor?
No.
There was never a suit?
Never.
No.
Never. No.
And it's not, one would hope, at the point of litigation, but can you say anything about where we stand with the DEC over the stockpile?
What we're doing, we have not heard back from the Attorney General. We had, as I stated before, we've had a dialogue. We haven't heard back. I was in contact with Cornerstone last week, and we're setting up a meeting because the village board has a direction that they want to go in. We want to put that in place so we're ready to hit the ground running when we need to be, whether we hear back from the AG's office or not. What that ultimately will be is up to the village board to decide, but we're in a position now, they have a lot of work. I don't think the village board's interested in letting the problem sit. So the problem needs to be addressed, we're going to address the problem.
Do I understand what you're saying to be that the governing party in any consent arrangement will be the AG, not the DEC?
Not necessarily.
Or that they're leading the process?
The AG's office, for reasons that the Assistant Attorney General was unable to articulate to me, took over the file. I asked him why. He said, I don't know. I was asked and I didn't. But understand that while we talk about the terms of the consent order, because there is no consent order as we speak, but we're discussing terms, certainly we've been up there. We have several emails. I mean, I think there's a course of action the building wants to take. We're going to go ahead and try to implement that.
Thank you very much.
Motion to adjourn.
May I ask one more quick question, please?
Sorry, get this off the record, we just need to.
That's fine. I had heard through the grapevine, and I just was curious if the village had any knowledge of this and if they might comment on it. I've heard that there's been interest expressed in the Arden Hill Hospital campus for Veterans Hospital.
No.
And that Walter Reed Medical Center has been interested in the site.
Wouldn't that be great? Wouldn't that be great?
No,
Find out more.
No,
We haven't heard any of that.
No, we haven't heard
Several years ago, I can tell you the county executive reached out
Yeah.
to the VA and they said no.